The hearing on the Committee on Public Information and Mass Media will now come to order. This is a continuation of our hearing from the last, but I'd also like to manifest for the record the members of our committee. We have 9 members, including Senators Laila de Lima, Senator Honasan, Hontiveros, Gordon, Ejercito, Pangilinan, and Legarda. Our ex-officio members include Senate President Pro Tempore Frank Drilon, Majority Leader Tito Soto, and Minority Leader Ralph Recto. This morning, I would like to acknowledge the presence of our resource guests. Maraming salamat po sa inyong pagdalo ngayong araw. Deputy Director General Vicente Agdamag, Attorney Reynaldo Ola Yusek Edwardo del Rosario, Attorney Norman Daanoy, Attorney Marie Banaag, Secretary Villar represented by Director Elizabeth Pilorin, Ms. Maita Bunales, and from the PNP, we have the Police Director General represented by the Directorate for Police Community Relations, Attorney John Reyes. And then we also have Colonel Wilfredo Villahermosa, Assistant Governor John Ravalo, Acting Deputy Director Rio Nuilan, Assistant Governor Corporate Counsel Edwin Carillo, and Director Jonathan Beltran. The Senate did not just tackle the FOI in the past, it had actually unanimously approved it in the 16th Congress in record time. So by March 10, 2014, it was already approved in the Senate, actually, in the Senate. If it were up to me, I will push the rewind, I will push the rewind button and replay the previous proceedings. But Senate rules dictate that we start again from square one. However, this doesn't mean that we will be starting from zero. We will also build on our past victories on the rich trove of accumulated ideas, and these will definitely accelerate the approval of the bill so that hopefully by December or January at the latest, the Senate would pass an FOI bill for the second and hopefully the last time. If you recall, the President specifically prodded Congress to pass a more comprehensive FOI bill, one that will cover the legislative and judicial branches. Therefore, this bill responds to the presidential challenge, but above all, it meets the demand of the people. As I have mentioned before, although the President's EO is laudable and we thank him for it, there's still an urgent need to pass an FOI bill so that the scope will not just be in the executive, but also in the 2 other branches, the legislative as well as the judiciary. Thus, we are not giving up. We're not giving up, and we're not going to make an exact replica of the executive order. Rather, we will strive to improve the material before us so that we would come up out of this committee, so that the committee report in this chamber will be a superior piece of legislation. As we buckle down to work, allow me to breeze through the elements of an excellent FOI law for our collective guidance. First is the presumption of release. This means that there's a blanket coverage for all public information and that all official documents are assumed to be open to the public unless expressly prohibited by law. Second is the requirement of clearly defined exceptions. These are the non-disclosure areas, typically on matters of national security, operational security, trade secrets, diplomatic security, and presidential privilege. Also included are information that could compromise law enforcement operations, endanger the life of an individual, or constitute an unwarranted invasion of an individual's right to privacy. Maglalagay po tayo ng do not enter signs, but in delineating no-go zones, we must see to it that they are clearly defined. The danger with vaguely worded exception is that they render the FOI law useless. Third is the creation of implementing mechanisms and agencies. Dapat matukoy kung ano ang gagawin at kung sino. The fourth trait of a good FOI law deals with efficiency and timeliness. For FOI to be effective, citizens must have access to what experts call actionable data, one that is immediately usable or which can be used to intervene in an urgent concern. Typically, what we see on government websites today are the after-the-fact data. Ibig sabihin, imbis na impormasyon na makakapigil ng suntukan, ang datos na nakukuha ay yung tapos na ang boxing. Ang panglimang katangian ay ang pagtatalaga ng mga parusa sa anumang paglabag sa FOI law. Ito ang tinatawag nila na fear factor. Without penalties, a law will be more honored in breach than in observance. Sa puntong ito, gusto kong ipagdiinan na ang FOI po ay hindi lang para sa mga mamamahayag, pero higit sa lahat, ito ay para sa mamamayan. There is this presumption that the FOI is purposely designed for journalists as aid in writing investigative pieces. But FOI is not just for the press, it is for the people. Let us also ensure that the bill we will craft thus empower agencies to carry out the mandate of the law. Agencies, to borrow a bureaucratic term, must be capacitated so they can effectively organize their information management systems and allow them to observe best record-keeping practices that would enable easy access and retrieval of information. Also, an FOI law should not just inform but educate. For example, the monitoring and dissemination of information on trafficking hotspots should be made available to OFWs so they will not go there. There should be an education component to the FOI so they will be educated on their rights and precautions. An FOI law should make the life of people easier. For example, there should be a one-stop shop for OFWs abroad which is accessible online so they do not have to go to the embassy anymore except for special circumstances. Processing of papers should also be an available service online. If an OFW was abused or his or her contract has expired or he or she were victims of or trafficking or his or her employee took away their passport, saan sila pupunta? Dapat kahit online man lang, makakapagsumbong sila. In today's hearing, we have invited representatives from different government agencies because the law will directly affect your work in government. Kung baga, kung mayroong pinatatamaan ng bill at kung mayroong mang kailangan mag-implementa nito, kayo po yon. Having said this, we shall now commence with our public hearing. I'd also like to acknowledge the presence of Mr. Limanzares. Let us now begin. I guess, does anyone here, any of our resource persons, actually have a presentation or a manifestation? We can give you the time. As you see, I'm by myself now. This is actually a good indication that our senators are confident with this FOI hearing, and I think that a lot of them will probably agree to an FOI law at the soonest possible time. So you have the floor, our resource persons. Can I begin with maybe the AFP, if you have a representative? Colonel?
Your Honor, good morning po. I am Colonel Wilfredo Villahermosa, the Chief Plans and Programs Policy Division of J7, the staff for CMO. Now, our concern only, ma'am, is for documents with national security implication, internal and external, ma'am. So, we have documents that must be protected and shall not be open for scrutiny for the public.
Okay, have you read a copy of the several proposed bills, or at least from the last Congress? The bill that was approved specifically points out that national security issues.
Yes,
uh,
ma'am. So that's the only part that we need to protect, ma'am.
So you don't have any other objections, or as to the wording of the proposed bill?
None, ma'am.
Okay, then that's good to know. This might be the fastest hearing we'll ever have. Um, let's see. How about somebody from the PNP? Do you have the representative, sir?
Yeah.
Wala po nagpapatay ng mic dito ngayon, so you're free to speak, sir.
Good morning, ma'am.
Good morning, sir.
Senior Superintendent Walter Castilleos of the Directorate for Police Community Relations, Chief of the Public Information Division of the PCR. In as much as we read last night and even before, a copy of all these bills, we have no objection since all the exemptions, access to information, were already discussed.
Okay.
Thank you, ma'am. Thank you.
Talaga. Oh, you're looking at our version of the bill, not the executive order, sir, ha? Okay. Thank you very much. How about from the Department of National Defense, Yusek Del Rosario?
Madam Chair, good morning.
Good
Ma'am,
morning,
I would
sir.
like to read the department position with
Please
regard
do.
to the FOI. We wish to convey that the Department of National Defense has consistently maintained the position that generally official records, documents, and papers pertinent to official acts, transactions, or decisions must be made accessible to the public in keeping with the constitutional right of the people to information on matters of public concern and in the spirit of transparency and good governance. Nevertheless, the Department subscribes to the exemption that state secrets bearing on the specifically sensitive national security and defense matters and those identified by the President in Executive Order Number 2 dated July 23, 2016 must be kept confidential and deemed privileged information. It is highly imperative that these matters be strictly kept from public access and only availed of by policy and decision makers whose assessments are vital to national security interests. Further, the Department supports the institutionalization of an effective mechanism that may allow access to certain information with national security implications to both chambers of Congress through an executive session. In addition, the Department also supports the exception in the Freedom of Information Act of personal information on a natural person to protect the confidentiality of personal information of our state officers. And finally, the Department shall participate actively in the formulation of specific policies to guarantee the people's right to information and yet sustain safeguards to protect national security interests. That's the position of the DND, ma'am.
Thank you, sir. But I would like to point out, while you support the Freedom of Information version of the executive, once we pass this Freedom of Information bill, this will supersede the executive order. So there are certain presidential communications privilege that will be adhered to, but again, our version of the Freedom of Information points out that it cannot be used to cover up a wrongdoing. And perhaps also with the DND, when it comes to national security, we may have a period of declassification. For example, maybe after 15 years, it depends. We will deliberate upon that, but it will also, I think it's vital because it should be part of historical records that future generations will be able to look back and study how our leaders were able to come up with a decision. So this is part of it. But I do appreciate that you recognize that there's certain information that needs to be discussed initially through executive sessions, even in the legislative branch. For example, when we had the Mama Sapano investigation, we had to begin there. But after sifting through all of the different statements that were manifested, we figured it wasn't damaging to national security to be able to release that. So I think we should not be careless about classifying anything so easily as for national security's sake. Because if we do that, then there will be like a blanket procedure of doing so, then it might be difficult for us to obtain information from the DND. Clearly, there has to be a segregation of what is national security for national security interests and what is just regular military operations that can be divulged to the public. So,
We subscribe, ma'am.
and also, so that you know, there's an automatic upload of the statements of assets and liabilities of certain government officials, especially the ones with flag rank, and also government officials, I think salary grade 22. Huh? Oh, salary grade 27 and above. So even in the local government, you know, certain mayors, governors will have to have that. Is there a representative from the local government or none from the local government? How about, may we hear anybody else who may have reservations about the bill or any manifestation? Miss, may I see your nameplate? National Privacy Commission. Please go ahead, ma'am.
Yes, good morning, Senator, Your Honor. May I be allowed to read our brief
Yes, please.
position for the FOI bills. So, good afternoon. I'm Ivy Patdu for the National Privacy Commission. So just this year, on April 26, our agency received several inquiries from two private individuals who expressed their concern regarding the online disclosure of a list of beneficiaries for a Department of Health medical assistance program in Davao. The data set, which was posted on the internet, was subsequently liked and shared by many netizens who came across it. So when the Commission looked into the incident, we were informed that the DOH had made the list available on its own website pursuant to the provisions of the General Appropriations Act of 2016. The law actually required the department to post on its website the name of government hospitals receiving state subsidy and the names of their indigent patients, whether confined or outpatient, and the types of medical assistance, services, and/or medicine they have been provided or given. The reason that this was stipulated in the law was for the right to information, for transparency, and good governance. We believe that both are essential elements of the right to information or freedom of information. Unfortunately, that same provision in the law failed to consider another equally relevant right, an individual's right to privacy. And in that law, those of the patients. We bring this up, Your Honor, because we believe that the framework of any law in freedom of information should give due regard to the individual's right to privacy. In most of the bills that have been proposed, we noticed a very broad definition of information. We noticed that in most of those bills, except maybe 3, only a paragraph was allotted to the exception for the individual's right to privacy. The incident we just described makes a good case as to why there is a need to balance these two fundamental freedoms that are guaranteed by the Constitution. On the one hand, there is utmost public interest in ensuring that public funds are spent on real and worthwhile government programs and projects by way of a transparent governance system. On the other, every person has the right to enjoy a reasonable expectation of privacy in his dealings with government or when providing information, personal information to government. In the DOH case, few would argue against a description of health information as consisting of personal data that is of a highly sensitive nature. That and yet a law ended up requiring the disclosure of patients' names, including their general addresses, in a very public medium. In doing so, the law exposed the people concerned to identity theft, social engineering, or acts of discrimination. Even if we consider that these might not lead to criminal acts, we know how a few years ago, when sensitive or unverified sensitive information about government officials and their health conditions became subject of rumors, it already caused concern. Just a few years ago, we also had the Cebu canister scandal. The fact that very sensitive information of people become available on such a public medium may already be considered an affront to human dignity. And thus, in respect for individual privacy is very important to us. Now, at present, the Data Privacy Act should not be seen as a hindrance to the freedom of information. It excludes from its scope those information referring to government officials, government transactions and contracts, and discretionary benefits given by the government. The law grants access to these information, which are considered matters of public concern. However, other information may still merit public disclosure in determining whether public access to them should be allowed. We must remain mindful of the individual right to privacy. Going back to the case that we gave as an example, the questions that should have been asked were, was it possible to promote the tenets of transparency in government in some other way without necessarily having to publish online the personal data of individuals? Could the patient's names have been redacted or at least visible only to specific individuals or offices whose mandates expressly allow them to verify the existence or merits of government programs? Would aggregate data have been sufficient? Questions like this should be considered in establishing the framework for the country's freedom of information framework, as do others, such as when someone requests access to a government contract, should it be necessary to include a photocopy of the identification card of one of the parties to the contract? When someone requests access to research data, should the names of the research participants also be disclosed? When someone wants access to information about corporations, should the individual TIN numbers of their directors be included in the ensuing disclosure? Ultimately, it should be clear that the Philippine government, through its various agencies and offices, collect and hold vast amounts of information about its citizens. They include data collected for social welfare benefits, health information in government hospitals or in the PhilHealth database, SSS numbers, GSIS numbers, voters' ID numbers, PRC information, and all those personal data people provide to the government in exchange of or when applying for services or benefits from the government. They are all personal data that should be afforded protection by the law. Admittedly, it may very well be simply about attaining the proper balance between the two fundamental rights on an individual case-by-case basis. The right to access to information and the right to privacy. Both hold the government accountable to individuals. Both promote an effective, honest, and participative type of governance. Both are considered hallmarks and prerequisites even of a truly democratic society. So, that's from
Deputy Commissioner Patdu, I really appreciate your manifestation. You know, even we've had several hearings on the FOI already in the past, and we've not had somebody make such a reasonable presentation on the right to privacy. It is vital that we uphold this, and I agree with you that it's appalling that they listed not only the names but the actual medications received and benefits from the hospitals. I think we need to be sensitive about that. You also raise a good point about if a company enters into an agreement with the government, should their private information be released? But before I delve into this further, and I think we need to talk about this, as I will also mention from our past bill what we had as a safeguard, so that you can also give your feedback on this. I would like to ask that we take a moment of silence to pray for the soul of an esteemed and a respected, courageous colleague, a woman who had helped us in the past also pass the Freedom of Information Bill. May we pray for Senator Santiago. She passed away a few minutes ago. So maybe I should also use this time to speak a little about her. As a junior, as a junior senator, as a young, well, not the youngest, but one of the youngest in the chamber at the time and a new senator, I was already defending the Freedom of Information Bill. It was the first bill that I defended on the floor. And I was quite scared to be interpellated then by Senator Santiago. I remember having sleepless nights preparing for that particular time when she would actually interpellate me. So at the time when I was finally given that opportunity, what she said was, before interpellating, she said, "Senator Po, I feel very maternal towards you." And so instead of actually interpellating me, she lectured me on the importance of having a Freedom of Information Bill. And I will never forget her for that. She stressed that that the presidential communications privilege should not be abused by any sitting president, and I think that's a valid point that we really took into consideration. And so this bill is also dedicated to her, and hopefully we pass it also in her memory. So going back to what you mentioned, in the past bill that we passed in the 16th Congress, we identified that while providing for access to information in public records, this act also affords full protection of the right to privacy of individuals as follows. A government agency must ensure that personal and sensitive information in its custody or under its control is disclosed only as permitted under this act. A government agency must protect personal and sensitive information in its custody or under its control by making reasonable security arrangement. An employee, officer, or director of a government agency who has access, whether authorized or unauthorized, to personal and sensitive information in the custody of the agency must not disclose that information except as authorized under this act. And we also have, I believe, Ms. Patdu, we also have in Section 7G that the information requested, we will also require that each department create a Freedom of Information manual, taking into account that there will be no unwarranted invasion of personal privacy. So we will probably have, for all government agencies, this manual, like an IRR, that will state clearly what an invasion to privacy could be. I think medical records is a no-brainer. It will be part of that, even for government officials, except, of course, when they have to disclose to their superiors the reasons why they need to take a leave or otherwise. We need to be very careful. I remember also that as candidates, your personal, I mean, all of us will have to, we ran for public office and we had to disclose certain information about our personal properties and dealings. But what was quite frightening is also including the full names of the children, including our TIN numbers, which is unnecessary in that particular with that particular exposure. I mean, yes, if we need to be investigated for something, why not? But I don't think it should be readily available, especially now that we need to keep sensitive information out of the public eye precisely because of certain online capabilities, and harm could be done with the disclosure of those information. So I see that we have ASEC Ablan. Welcome, sir. Are you ready? Are you ready to give your presentation, or Ms. Banaag, Attorney Banaag, both from the PCO? Because it's important. I remember working also with the PCO. You're our partners here. You're there to protect the president, but ultimately, you're there also to uphold the interests of the public. So I would like to hear any manifestation that you might have.
Good morning, Madam Senator. We have a presentation. If we can access the LCD projector.
Aside from the PCO, sir, and you'll also have a presentation. Oh, would you like to add something? Sir, may I see your nameplate? I'm sorry, I can't see it from here. Oh,
Albert
Comelec.
Rodriguez, ma'am, from the COMELEC.
Yes, please. We'd like to hear from you.
Good morning, Madam Senator. Upon initial discussion with our Executive Director, Your Honor, we fully support the passage of the Freedom of Information Bill, or this particular bill, Your Honor. We fully support. However, Your Honor, we just like to reiterate, Your Honor, that the provision particularly on Section 9 of Republic Act 10367, or the biometrics law, be maintained, Your Honor, and not be deemed repealed by this freedom of expression, Your Honor, because said Section 9 of Republic Act 10367 states that the database generated by biometric registration shall be secured by the Commission and shall not be used under any circumstance for any purpose other than for electoral exercises. Although, Your Honor, upon perusal of the bills, the proposed bills, we noticed that those information protected from disclosure, exempted from disclosure by law or by the Constitution, shall be respected, Your Honor. That is the only concern of the Commission, Your Honor. That the protection given by the mandatory biometrics law be recognized, Your Honor.
Perhaps it will not be made public in your website. This is actually information that will be readily available. We certainly don't look at it that way, but if you are required to submit copies of the biometrics data, maybe to, well, of course, even now to the legislative branch, you need to do it.
Of course, Your Honor. Thank you, Your Honor.
And Attorney Escudero from the Civil Service Commission.
Yes, thank you, Madam Chair. We noticed that the concerns we raised during the last Congress were already addressed by the bill. I just have one minor observation on Section 21. The enumerations, the acts enumerated there are constitutive of, if the intention is really to make it as a grave offense, we might as well particularly name it as gross neglect of duty. And if the intention is really to penalize the acts enumerated there as with dismissal from the service, I suggest that we also mention that already in Section 21.
Mention what particular phrase?
Because
That it
Section 21, Your Honor, states that the acts enumerated in the subsection shall be tantamount to grave administrative, offenses. There are so many grave administrative offenses, and the acts enumerated here are they are really they fall under the offense of gross neglect of duty.
So you want us to include the term gross neglect of duty?
Yeah, instead of,
Of grave-
just saying grave administrative offenses, to make it more clear.
What is the
Your Honor.
difference between, how will it help, again, if we say grave administrative offenses as opposed to gross neglect of duty?
The particular offense, Your Honor, is already mentioned. It is clearer to the person who will read this, to everybody. It will be clear to everybody that the offense is really gross neglect of duty.
So these
Because
are,
there are so many grave administrative offenses.
but the gross neglect of duty, there's just a few of them? Or it's more,
It is more descriptive of the offenses of the acts enumerated under the subsection.
okay, well, thank you. Thank you for helping us with the terminologies for the civil service.
You're welcome, Your Honor.
Any
Thank you
other
very much.
concerns, sir?
No more.
Okay, ma'am, were you raising your hands? May I see your nameplate?
Good morning, Honorable Senator. I am Maita Bunales from the National Archives of the Philippines.
Oh, yes.
So we would like to give our manifestation. Under the RA 9470 or the National Archives of the Philippines Act of 2007, there are maybe implications on it divested the power or authority of our executive director. Under Section 31 of our law, the grounds for determining access status as the head of the controlling government agency shall be in consultation with the executive director of the National Archives. On the proposed law, Your Honor, it divested the power of the authority of our executive director. Because there must be a consultation with the controlling agency, meaning the owner or the creator of the record, before they can declare those records as open access. Kasi dito sa proposed bills, parang prima facie presumption that all records created by a government should be open access.
It should be. Are you
Yes,
trying to
but-
say that we should seek permission from the National Archive before doing so?
Yes, kasi there are restrictions on the RA 9470. There must be consultation with the executive director or the head of the agency of the
Well,
National
then
Archives.
I guess we will have to repeal that because that will add another layer and will defeat the purpose of having easy access to information. So
Yes.
we will get a copy of the law that created the National Archive if there's a particular provision there that will be in conflict with the freedom of information, but definitely that is something that I'm glad you call our attention to it so that we can have whatever needs to be corrected will be done. But the National Archive, do you have the capability? How is your archiving process now?
We're doing our best, considering that we don't have a building of our own, but we're trying our best to be at par with other archives in other countries.
But do you have your own structure already, or are you still?
We have our own system, yes.
No. Do you have your own building?
No, not yet.
You're-
That's an
you're
issue.
just renting?
Yes. We're just renting buildings to house our voluminous records.
Okay. Have you digitized already certain?
Yes, we are undergoing digitization of our permanent records.
How many?
Archival.
What is your priority? Which documents do you is considered priority for digitization?
All records in the National Archives per se are all permanent, meaning they have been declared having historical or archival value or research value for the public to in the future if they want to get information. But we've been digitizing for the past, I think 15 years already.
And
To
how many
make-
people is doing that process for you? How many
sorry, Your
employees do
Honor.
you have? Are you outsourcing it or are you doing it yourself? the
We are
digitization?
outsourcing it, Your Honor.
Okay. So how do you do it? You actually take the picture of the document?
They have to scan it. Scanning of the document, digitizing them from the hard copy, the traditional one, we digitize them to have a electronic copy. And then if the public will request one, we'll have just to see the
Give me an example. For example, an individual will go to the National Archive. What information is digitized already at this point? Is it all executive orders of the president from the past, or?
We don't have a copy of the executive orders. Records in the National Archives are the earliest is the 1300 documents. These are whatever created and maintained during the Spanish, nasa pangangalaga po ng National Archives.
So nasa Castilla period pa lang tayo
Yes. Yes, Your Honor.
sa pag-digitize.
Yes. Part of those records have already been digitized.
Okay. That's good to know, I guess. but-
Your Honor, I have also some manifestation on
Sure.
there was a mention on the proposed bill that SALN should not be destroyed. I wasn't able to mention ano po yung bill na yon, the proposed bill na yung sino po yung author na senator. But it says that the SALN should not be destroyed.
I'm
But
sorry, which one should not be destroyed?
the statement of assets, liabilities, and net worth.
Meron bang nakalagay dun sa...
There is a proposed na-scan lang po namin. I don't know kung sino pa yung author nun.
Hindi, sino nga?
I'm
The
sorry to-
SALN should be destroyed after a while?
Yes, but SALN has a retention period of 10 years only. So
I
except
think it should
kung,
be forever.
yes, it's not should be forever.
Okay. Sige, never mind. You don't have to disclose that.
And then,
yes.
yes, Your Honor, I have an additional. As to liability on destruction of public records, under the National Archives Act or the 9470, it is an offense for a person who willfully, negligently, or damages a public record or disposes or destroys a public record other than in accordance with the RA. But dito po sa mga law, yung ibang proposed bill, naka-mention lang na doon lang siya papasok sa criminal liability under the revised penal code. So dito po sa RA 9470, ang penalty po if a person negligently damages, destroys, or disposes a public record, mayroon po siyang penalty na a fine of 500,000 pesos but not more than 1 million, or a penalty of 5 years but not more than 15 years, or both. So yun po yung ano namin, yun ang kaakibat doon sa RA 9470. Dito po sa ibang proposed bill, nakalagay lang po na papasok po siya yung kanyang criminal liability based on under the revised penal code.
Okay. Any more concerns, ma'am?
Yun lang po, Your Honor. Thank you.
I think the PowerPoint, maraming thank you for calling our attention also to your particular concerns of our version of the bill. I think the PCO is now ready for their PowerPoint presentation. ASEC Ablan.
Thank you, Madam Chair. The Presidential Communications Operations Office supports the measures filed in Congress since the executive order number 2 is limited to agencies of the executive branch. With the approval of an FOI bill on FOI Act, it would involve other agencies, including constitutional bodies, the legislature, and the judiciary. Also, the bills include formalizing open data and proactive disclosure, which the Presidential Communications Office advocates. So the update we will be sharing with you, Madam Senator, would be the update on the FOI program of the executive branch under EO number 2. We have a deadline. The executive order ordered the OSG and the DOJ to submit a list of exceptions. The deadline was on 27 August. Both agencies submitted their list of exceptions on time. The OSG on 17th August and the DOJ on the 23rd August. As of the moment, the Office of the Executive Secretary is still reviewing these exceptions. The exceptions, of course, are no secret. It was known by the media that the OSG submitted over 160 and the DOJ over 60. Next slide, please. What the PCO proposes, but of course it has no, the executive secretary has the final say, is to limit the exceptions into 10. And you're able to limit the exceptions to 10 if you categorize. If you look at the slide, on the left side, you have Australia. The exceptions to FOI in Australia is limited to 9. It doesn't mean it's just limited to 9 documents. It just means it's limited to 9 categories. Also on the right is the exceptions to FOI by the US. It's also just 9. So it's easy to understand by the people. We don't have to list each and every one. Perhaps this list can be in the people's FOI manual with regards to the specific documents that could be in the implementing details or the agency's FOI manual. What we advocate is to have 2 manuals, a manual for the people and a manual for each respective agency. You will notice, Madam Chair, that there are similarities. Of course, primary is documents involving national security. Both Australia and USA have that. You also have law enforcement documents, documents with secrecy provisions, cabinet documents. Another category which is similar in many jurisdictions would be trade secrets. You have confidential documents, legal professional privilege, those subject to contempt, and electoral polls. In the US, you have law enforcement documents, and a perusal of the different exceptions listed in the different bills can fall under this third exception, exemption by statute. So by simply just stating that if a document is exempted by statute to be under FOI, you thereby reduce the number of exceptions into just one category. We go on with interagency memos, personal information to be consistent with the Data Privacy Act, internal rules, documents of financial institution regulators, and oil well data. Next slide, please. The timeline for the executive branch, well, the official rollout would be on November 25. We determined November 25 by counting 120 days after the publication of the executive order, which was on July 27. So the deadline for all agencies to release their FOI manuals is on November 25. The executive order did not require a specific agency to come up with a model FOI manual, but the PCOO, since it's the agency designated to operationalize FOI in the executive branch, thought it be best to provide agencies with a model FOI manual. We submitted our model FOI manual to the Office of the Executive Secretary last September 22. And so we are just waiting for the Executive Secretary to approve or to put his recommendation. This is a we are optimistic that we could release our model FOI manual to all agencies by October 7, but this is again dependent on the approval of the Executive Secretary. After that, we intend to organize FOI workshops on the 13th and 14th of October and the 20 and 21st of October. This is with regard to standard FOI. The bottom part of the timeline shows our timeline for e-FOI, which I will explain later. On October 7, we will have an initial e-FOI workshop with selected agencies. We've already invited the selected agencies to participate. These agencies are agencies who have been proactive in disclosing their documents. And so we have convinced these agencies. These include the DICT, the PSA, the DBM, the DOF, who have been proactive in disclosing public documents. And then on the 27th and 28th, we will have a formalized e-FOI workshop. And by November 25, we hope to have a rollout of the beta of the e-FOI of the executive branch. Next slide, please. The contents of the model FOI manual is just a flowchart. This is a simplification of the flowchart. Basically, an interested citizen would file a request with the FOI records or receiving officer, and the FOI records or receiving officer will conduct an initial review or evaluation of the application. Madam Senator, the flowchart is based on your bill. It goes to, we just changed the names of the individuals. So after performing initial evaluation, then it goes to the decision maker. The decision maker can either be a director, an assistant secretary, or undersecretary. The decision maker either approves or denies the request. It goes back to the requestor. If it's denied, the requestor is given an opportunity to appeal the decision to an appeals committee, and thereof we go through normal administrative procedure in appealing cases all the way up to the Office of the President. Next slide, please. The Model FOI manual also contains a sample request form, which is again consistent with the bill of the chair. It includes that it should specify the name of the requestor. It should be written. She should be able to identify himself or herself, identify the document needed, and the purpose. On the right side, you see we also provide a response template such that the decision maker does not need to think of how to reply. He just has to choose between which among of the options to use in the responding to an FOI request. Next slide, please. In consultation with other agencies as well as our technical consultants, the World Bank, we were made aware that in other countries, in other jurisdictions, when they implemented FOI, it's possible that in the initial rollout, we will have long lines of people who are interested to determine different kinds of information, and we anticipate a big burden to our frontliners, those who will be tasked to be the designated FOI receiving officer. Next slide, please. And go back to, just to emphasize that our receiving officers may be existing officers of the bureaucracy already, and by providing them with an FOI task, we will be further stressing them out, and you know, we will be using so much time. So, next slide, please. Okay, based on international experience, please press the next button. You see that the first year of implementing an FOI, you see a surge. There is a surge in FOI requests. So what we do not want to happen is that coming November 25, all of our agencies will be overburdened with FOI requests, knowing and recognizing that we have our own jobs to do. So what is the solution? The solution is already in the proposed bills, which is to adopt proactive disclosure. Next slide, please. Proactive disclosure is to make as much government documents public, and this is to reduce the burden on public administration of having to process requests for information. The proposal is to continue the open data program. This is an existing program, Madam Chair. The UK, Australia, the US, India, and New Zealand have taught us to embrace proactive disclosure to complement freedom of information. In proactive disclosure, government makes as much of its documents available to the public. This has been seen to reduce the burden on public administration of having to process standard paper requests. In Australia, open data reduced FOI requests by 31% for the period covering 2014 to 2015. Fortunately, like I mentioned earlier, there is already an existing facility. This is the Open Data Program, formerly under the DBM, now under the DICT. PCO proposes to continue the Open Data Program under the Philippine government's obligation in open government. Next slide. This is the envisioned FOI program. So from just a program which is supposed to be just a standard paper request program, we try to have an umbrella program which includes open data, and then you have FOI, and underneath FOI you have e-FOI or electronic FOI, and standard FOI requests. In e-FOI, the requests can be made online. In the US, FOI Online saved the federal government an estimated $40 million that year. In New York City, e-FOI reduced FOI costs for the city by 66%. PCOO intends to partner with DICT, DBM, PSA to implement this proposal. The World Bank, as our technical consultants have offered to further assist us in this endeavor. The PCOO has drafted an administrative order creating an interagency committee for open data and EFOI, and this has been submitted to the Office of the Executive Secretary. Next slide. All right, on the left, you see a standard FOI, which is a paper-based request. On the right side, you see an EFOI or open data. You see the frontliner now happy, pointing out to the requester that he or she may avail of EFOI instead of lodging a regular paper request. The end goal is to provide citizens with the traditional mode of requesting for information through standard FOI paper requests and provide them with the options to download information in open data or to lodge a request online via EFOI. Thank you very much, Madam Senator.
Wow, I really commend you, ASEC Ablan and the PCOO. You've actually taken proactive steps already in rolling out an FOI program. Actually, what you're saying about open government, automatic uploading will certainly help. We're actually a signatory to the Open Government Access in New York, and I think we're one of the first countries that complied, that agreed to it. So certainly what you're doing is very commendable. I'm just a little bit concerned about, no, I think it's good, and I think you're right by stating that there should be categories. That's why when they look at the president's version of the FOI, it seems like there are too many exceptions because it was mentioned in detail. But let's say right to privacy, medical records, for example. I think there's a sub condition also about AIDS, and there are many different categories that were mentioned that could be under the non-disclosure of health information, etc. So I think that you're right. We need to be able to put categories, but we can't have. We have to be careful not to say, for example, we can't say, for example, legislative documents, because that means that a lot of it everything will fall under it. But I'd like to acknowledge the presence of one of our most hardworking colleagues, Mr. Testaman himself, who had to be here today because our spouses are here also. Thank you. May I ask if anybody else has a manifestation? Wait, before I do that, sir, would you have any question for the PCO? No. Later, okay. From the Bangko Central, Assistant Governor Ravalo.
Thank you very much, Madam Chair. As a matter of basic principle, we totally support the premise of accountability and transparency. We do ask the Chair, however, for her indulgence. We will formalize our position paper in about 2 weeks' time. It's actually being written right now. We will just seek internal clearances. But going back to my point, Madam Chair, about accountability and transparency, the reason why we are fully supportive of these two principles is because it's essentially the very premise of effective supervision, for which is the role of the Bangko Sentral ng Pilipinas. We submit, however, Madam Chair, that we would request the committee's indulgence to take a look at the peculiarities of the financial market, some of which has actually been raised in many of the interventions. If the public and the financial institutions are fully aware of what each other is doing, there really would not, in theory, be required a regulator. Financial markets are so structured where information is always a commodity by itself. And there lies the role of a regulator to try to balance the context of what information, when is it required, to whom is it of value, and the primordial interest is not just certainly not the institution by its very self, but the public at large or the national interest at large. But let me, Madam Chair, cite 3 particular cases. If the context of the requested information is such that the financial institution is believed to be performing illicit or unsafe and unsound practices. There are existing guidelines today across financial regulators. In the BSP, we call it prompt corrective action. We don't wait for the bank to show manifestations of outright weakness in the context of our examination on-site as well as the context of our regular CPC engagements with the banks. We are able to get a feel whether there's something peculiar, something different about the management of this particular bank, and we are able to dig deep. In the instance where we believe there is sufficient basis, then we engage the bank to go into prompt corrective action. So there is already that particular framework for that case. In case 2, Madam Chair, is what if it is the transactor, the client of the bank, who wishes more information about the status of the bank or a particular product or a particular transaction? Certainly under current market practice, not only do we encourage that, that is really the right of a client. Pera po niya yun eh. So, wala naman po sigurong pagbabawal na itatanong ko, pera kung binigay ko sa iyo. Gusto ko lang malaman kung saan mo ba ginamit. In the context of consumer protection, financial literacy, we always remind the public na huwag niyo pong hintayin na magsarado ang bangko. Kaakibat po kayo sa responsibilidad na dapat malaman natin kung ano ang tayo ng ating mga bangko. Dahil pinaghirapan po natin yung pera na yun. No? And we see that, Madam Chair, particularly in cases where meron pong mga pamilya na yumao na po yung kanilang nanay at tatay, hindi nila alam ang tayo ng bangko or hindi nila alam yung kondisyon na kanilang deposito sa bangko. So we would have to intervene in that case, and it would have been so much more transparent if there was direct contact. So, Madam Chair, then, therefore, that leaves only case 3, which is what if the requesting party is not a transactor of the bank or a regulator? Magtatanong po, paano ko po kung ang sitwasyon ang nagtatanong po ay competitor? Paano po kung meron pong different interest po yung nagtatanong? Hindi naman po natin malalaman kung anong interest nung nagtatanong. So the challenge, Madam Chair, is really whether when the requesting party is not a direct stakeholder to a financial transaction. The chair opened the session by talking about do not enter and no-go zones. Hindi namin po we don't necessarily think of it as no-go or do not enter zones because we believe currently we are also held to the standard of a public servant. Meron po kaming accountability. Hindi naman po kami pwedeng gumalaw ng basta-basta. As the chair knows, the Philippines is one of the very few jurisdictions in the world where a bank supervisor can be sued. Most other jurisdictions, exempted po kami sa suit. Kami po hindi. Kami po ay nahahabla. In my particular context, one of the units I handle is consumer complaints. Katiting na po ako mahabla dahil hindi niya type yung sagot dun sa consumer complaint. So we are simply saying, Madam Chair, that when it comes to finance, there might be reason for pause to try to consider the peculiarities of financial transactions, given the context that there is already a viable framework for interacting with illicit transactions or banks that are performing unsafe and unsound. There are also deposit secrecy issues, and there are other manifestations or initiatives in Congress that we would like the Congress to consider with respect to improving the situation. So, hindi po namin sinasabi na perpekto na po yung sitwasyon. Kaya po kami, we are advocating also with the indulgence of both the Senate and the House, amendments to our charter, amendments po doon sa AMLA law para hindi na po maulit yung nakita po natin recently. We're also advocating amendments, for example, for sa Philippine Payment System Act. Kasi wala pong regulator ngayon ng payment system sa buong Pilipinas. Magtatapos lang po ako doon sa punto na meron po bang other regulators or central banks na nag-a-advocate ng hindi naman po do not enter or no-go, but really a form of exemptive relief with respect to the absolute granting of freedom of information. Nabanggit na po kanina ni Asek Ablan na sa Amerika, meron pong documents of financial institutions are not covered by freedom of information. Bank of England also has an explicit coverage against indiscriminate sharing of information. The context in both cases, Madam Chair, is not to protect the bank. The context in both cases is really the prudential framework which we refer to as financial stability. Para po masigurado natin na yung information na gagamit. In the three cases that I mentioned earlier, Madam Chair, in two of the three cases, we already have that covered, from corrective action as well as the direct motivation of a transactor. Ang problema po natin, paano po yung nagtatanong, may iba pong balak. At mahirap naman po basahin yung mind ng tao at the point that they are requesting information. So with that, Madam Chair, again, may I reiterate we are very thankful that the Bangko Sentral is invited to this hearing, and if the Chair would allow us, we would submit a formal position paper no later than 2 weeks from now, Madam Chair.
Actually, as Gov. Ravalo, we really appreciate your manifestation, and you made some very valid points. Certainly, you're right. Your institution, the financial institution, is very peculiar, and sometimes too much information can spook the markets also. And we need to be a little careful about this. So, but if I may make a request, I know that you have a lot of work, but we're also trying to fast track this one. So if you can finish it in a week, we just look at the particular provision that will affect you. One of the exceptions that we have is if the information requested pertains to trade secrets and commercial or financial information obtained from a natural or juridical person other than the requesting party, obtained in confidence or covered by privileged communication, etc. So we have here some provisions, but maybe you can polish it a little bit so that it will not be used for abuse, but we don't want it also too stifling, so that those that are really legitimately seeking information on the status of their deposits or the status of the bank will be given information. But you know what? Sometimes, even if it's the competition seeking information, they can always get a third party to do it for them. So we'll never really know if that person is actually doing it just for his own benefit as a depositor or as an investor, or doing it for another party. So we'll just have to figure out how to be able also to protect our banking institutions. Ma'am, did you want to add something?
Thank you, Your Honor. Actually, the provision that you mentioned related to financial secret of a natural or juridical person as an exception, we view that it does not cover the concern of the Bangko Sentral. And with your indulgence, may we request that specifically results of financial supervision examination as well as conduct of monetary policy be specifically cited as among the exceptions or exclusions to access to public information. As mentioned by Assistant Governor Ravalo, these are the specific items that are also set forth in the Freedom of Information Act of the United Kingdom and the US. So specifically for Bank of England, it's still a government agency, but with respect to that particular information, it is excluded precisely because of the nature of operations. So we will suggest
All the financial jargon, okay? So I don't claim to be an expert in that. So you obviously have, you obviously know what to do with regards to this. So please prepare it based on what we already have, and try to make it something that's workable, but at the same time that it will not be subject also to abuse by others. So I leave that up to you. I think if you start with the provision that we already have, I think a week is enough. If you just fix it, you don't have to give me a lengthy position paper, because what's going to happen is we'll have to sift through it, and we might not be able to retain the meat of what you want to include. So just work on the provision, add to it, or take out what needs to be taken out. I think, is there any other position from the PIO? Dr. Beltran,
Yeah.
Director Beltran.
From the Commission on Audit, ma'am, we welcome the enactment of an FOI. based on our experience, there are requests for documents and information in the commission audit that requires authentication. Going through the 13 bills that that are in here, I didn't see any provisions for authentication of documents, so I think it should be included also.
Authentication of
Authentication
documents. Within.
Yeah.
I'm
for
sorry,
example,
sir.
it's an
Give
annual
me-
audit report to be used in a case, and a certain government agency requests that the annual audit report be authenticated by the commission audit. So there might be requests in the future for authentication by the government agency concerned, and I think the 13 bills does not cover the authentication of documents. So I think it should be included.
So what you're saying is, if I request for a document, let's say from a COA report, and it will be presented, let's say, in court, what you're trying to say is that if they obtain it from another agency, they have to go to the COA to have it authenticated for this to be a valid information provided.
Yes, ma'am. There are some cases that there are some requests like that. They require that some judges require authenticated documents.
Well, you know what? Then the judges can just specify that. We don't have to put it in the law.
Okay.
As long as it's made available, it's also the responsibility of the requesting party to do the authentication. But yes, thank you for calling that to mind. It will also remind the public, make sure that the information you're getting is hindi gawa-gawa lang nung information desk, di ba? Para tumahimik kayo. So,
I may interject, Madam Chair. If you talk about authentication, how long does it take?
Oh, the request process, we do have a request form, and this is evaluated. If it is approved and the party requests authentication, it may be within the day, depending on the volume of the document.
It's not gonna take a year
No,
or
no.
so. Madam Chair, just a reflection. I've been listening to our resource speakers, and it's clear now that FOI should not be looked at as government interest versus public interest, because even if you look at in the government agencies, tayo dito nga ho mismo sa Senado, in so many of our hearings, we would ask for documents, babalik yung next hearing, wala pa rin. Minsan 2 buwan na, wala pa rin yung mga documents. So, I think it's really important na tayo din mismo sa gobyerno magkaroon tayo ng right coordination para in preparation dito sa batas na gusto natin lahat. And I think all of us are very much in support of this particular measure. Thank you, Madam Chair.
thank you, Senator Villanueva. I think we have a representative from the SEC present here today in the gallery, or sir, welcome. Would you can you state your name for the record, sir, and your designation?
Madam Chair, I'm Attorney Camilo S. Correa, General Counsel of the Securities and Exchange Commission. We beg the Chair's indulgence if we are still not able to submit our position papers on the various bills filed on freedom of information, because we would like our comments to be well studied and of value to the Chair's committee. And we are also in the middle of complying also with the executive order on freedom of information. May I just add, Madam Chair, that earlier there were discussions about open government, and we would just like to raise to the Chair's attention that at SEC, as the corporate registrar, to some extent we have operationalized the concept of open government, because as corporate registrar we have made available to the public the filings, corporate filings of registered corporations, and these are basically their articles of incorporation, their bylaws, their annual financial statements filed with the Commission, as well as the general information sheet, which is filed after the annual membership meeting of all corporations. So any interested individual can access it through the internet, because it's there's a clickable link in the SEC website which would give them access to this information.
Well, I'll also make this request from you, as I did also with the Banco Central, if you can submit within a week so that we can start working on the provisions that we will be submitting. To make it easier for you, go back also to the last bill that was passed in the 16th Congress. I think most likely it will harmonize and it represents also the different positions on the several bills filed on this. So it will be easier for you. Look for the particular provision that concerns you and then work from there, sir.
Yes, Madam Chair.
Maybe
we
1
will.
week.
We will, Madam Chair. You're right. We are just taking another second hard look on what we have previously filed with the committee and with the Senate, as well as with Congress. If I may also add that, well, also as a member of the Financial Regulators Club, together with the BSP and of course the Insurance Commission, the SEC regulates the equities or the securities market. We are also guided, I would say guided but not circumscribed, by the certain provisions of the Securities Regulation Code which holds certain information as confidential unless we reach a certain stage, like information on investigation and investment scams, things of that sort, Madam Chair.
It can also, because you can also use as an exception ongoing criminal
It
investigation.
would
So,
fall,
yeah.
yes, Madam Chair, it would fall under that category.
Thank you, Attorney. How about the DPWH? Of course, you handle a lot of probably the costliest projects all over, and it's been subject to a lot of concern also how the DPWH disburses funds and which projects are completed, etc. One of the things that we propose in our bill is that government contracts that is, I think, 50 million or more is automatically uploaded in a website. I would like to know now what the policy is or the procedure of the DPWH. Are all your ongoing projects accessible online right now?
Good morning po, Madam Chair. In our DPWH website, we have a lot of information already uploaded, including the projects that are ongoing, completed, and some even the names of the contractors that some contractors are complaining because they're being subjected to taxation with the revolutionary tax.
Ba't kayo natatawa dun sa mga...
Kasi po na gusto namin i-disclose and yet na ano naman yung kanilang security. Kasi yung they're being subjected to revolutionary.
Well, you know what, perhaps, ma'am, the general information, the name of the,
the name of the
contractor,
yes, ma'am.
hindi na kailangan siguro yung mga TIN number or whatever, but kasi part of this, if you get into an agreement with the government, you have to make certain disclosures.
Yeah, yeah, that's
Like-
our concern, Madam Chair. Because under Secretary Singson before, he wanted this to be uploaded in the website, and really some private contractors are really complaining on the amount of the contracts, even accounts payables, accounts receivables.
But I think that, and then if they're not comfortable with it, then they shouldn't be working with the government, because
Yes.
one thing is, capitalization is also important. Members of the board of a
Yes, ma'am.
particular company, as we see that there's always that
Yes,
conflict of interest issue, especially when it comes to the maintenance of the MRT. So these things, I think you're at the forefront of preventing corruption here. So your website is vital to providing that initial information. And if they want to dig deeper with the IRR that we will be providing, you should have an FOI desk, I think. Certainly the DPWH will need that. So what else?
Madam Chair, we have already an existing system process wherein our stakeholders can request information from our office. A lot has already been, even if there is a lot of information now uploaded in the website, many stakeholders still come to our office and request for hard copies of the information. In fact, we have in the website our infra statistics, the roads, the list of roads, the bridges, roads and bridges statistics, even archives. We have the completed and ongoing project per region with the following details: name of project location, contractor, implementing office, source of funds, project cost, and implementation schedule. We
How
have-
about items to bid also you have there?
Yes, ma'am, we have, ma'am.
How about the SALN of your secretary?
No.
Oh, then eventually that will be there.
Opo, yes, ma'am.
Hindi balik sa inyo yata yung pinakamayaman na secretary. Eh. Wala. But I would also like to ask, do you have, do you post the names of blacklisted contractors or the ones that had violations in the past?
I think we have releasing names of the blacklisted contractors, ma'am, because blacklisted contractors, sanctioned contractors are issued with the corresponding department orders signed by the secretary. And department orders are accessible in our website.
Okay, good. So, but you know what? Part of it also is it making it easier for those seeking information to sift through the information. So
Yes, ma'am.
instead of it coming from orders by the secretary,
Yes, ma'am.
and then they have to go through each and every one of them, I think you should have a separate column or list just for the blacklisted contractors.
We will do that.
Yes, and also maybe if there's anything that you should exclude from the freedom of information, are the names of the government officials and local government officials who are implementing the projects in all of those billboards and tarpaulins that they have in these projects. I don't think the people really need to be notified of that. Right? That's part of our mandate and our responsibility. Okay.
Madam Chair, if
Yeah,
I may,
yes, sir.
in following up from what you are stating, Madam, how do you qualify this information, the gathering of information that you're talking about? For example, ma'am, do you intend to get the cost, for instance, for every 100-meter road, this ganito kakapal? For example, sabihin ito, worth 1 million, this, ganito yung kayang puntahan, so that you can easily compare. And this is one of our goals in passing this measure. So again, going back, how do you qualify the information that you are trying to get from these contracts? And I'm not expecting, for example, every single screw na magkano ito, etc. No? I just wanted to make sure that we can, with this measure, we can engage our citizens para alam nila na hindi sila naloloko dun sa mga projects na ini-implement ng ating gobyerno.
Sir, meron po kaming yung as per design, yung mga design standards, they're already there in our website. And we have already a system in the department, is the price cost analysis. I think it's not yet still in the, because we are still in the process of constructing the system. Every region has different prices, yes.
And a lot of questions, I'm sure you've encountered this, no? Yung pag by administration, bakit mas mura? Pagka, I'm sure, di ba? And a lot of our people would keep on asking that question. So I hope ito maging mas malinaw with in preparation dito sa FOI.
We will take that into consideration, sir. Thank
Anybody else would have a manifestation? PCO, okay?
Ma'am, just before if before we forget, may we we will submit a proposed definition of a matter called the mosaic effect. I was not here when the PNP made the presentation, but the mosaic effect is when a data set is revealed, several data sets are revealed from different agencies, and taken in isolation, that particular information does not endanger the privacy of a person, but by collating the different data sets from the different agencies and combining them, there is a mosaic effect that it's possible that the complete identity of a person can be made and used against him. And so we will propose a definition and reference to the mosaic effect, such that before disclosing, agencies should consider whether the information they're disclosing may contribute to a mosaic effect, such that it would endanger the life of a person. For example, they would receive a information, maybe they get the TIN number from a contract from DPWH, and then they check on the SEC and they're able to get the passport information. So little by little, they're able to fill the complete information details of a person and use it against him for to post. So that should be a concern of the measure, to recognize the mosaic effect. It's been recognized in the US, and we will the PCO will submit a proposed provision to be inserted if it's amenable to the senators.
Well, we really appreciate that you brought this up. Certainly a concept that has just been brought up now that we didn't have the last time. So thank you. And there are certain things, though, that you waive. For example, you opt to that you decide to deal with the government as a contractor. There are certain things that you'll have to be able to sacrifice and information. Like us, also government officials, we need to be able to sacrifice information such as our statements of assets and liabilities. But for an ordinary individual, guarding the privacy of that individual, you're right, we have to be able to harmonize the different allowable information on such individuals so that they won't be able to get information piecemeal from one and then the other. Like, for example, I think what really alarmed me was that information, Ms. Patdu, that you brought out about the health situation, because if you get certain unredacted names from a government database and then you go to another one and you will find out the history, that could be frightening also. So yes, please submit that by all means. We would like to protect the individual's right to privacy, as we also want to be able to give information and empower our other countrymen. Yes, of course.
In addition, no, kay ASEC from PCO, I was listening attentively with your detailed report about the experiences of other countries. Not only for PCO, or maybe for other participants here who look at the FOI experience in other countries, do we have any information on how increasing transparency in this particular countries affected their investment climate? Probably it's also a good data and research that we can gather. We heard in the case of the mining industry, for instance, yung increasing transparency through the Extractive Industries Transparency Initiative, yung EITI, actually help improve investments in the said sector. Perhaps if we can also add this particular issue doon sa research po na ginagawa nila. Thank you. Unless you have data right now, or if there are other participants here who would share their experience or their research in other countries' experience with regard to increasing transparency. Thank you.
Yes, ma'am.
Madam Chair, we'd also just like to request for the week to submit our position paper on specific provisions. We'd like to suggest for the terms to be harmonized also with the Data Privacy Act, which is present in some of the bills already, and to express support for some of the provisions in the bills, which include redaction, partial release, and all the other items that would have an impact on privacy. So may we also submit within a week our position paper.
Of course, we
Thank
will
you.
welcome that. Senator Villanueva's being very generous. Ikaw daw, more than a week, hindi. Actually, on me. Let me go back to DPWH. Meron feedback lang dito na nagsasabi, your website is not user-friendly. Mahirap daw. Alam nyo, minsan kasi sa mga kaso, para ayaw sasabihin, oh, we need that information. Ang ibibigay sa'yo, isang kwartong puno ng dokumento. Nang sa gayon, hindi mo makita yung hinahanap mo, a needle in a haystack. So that's what maybe the DICT will have to work with the DPWH and all other agencies so that we have a standard format, hindi yung parang kalat-kalat dito, may PDF pa dito, di ba? Ang PCOO, I think you're proactive enough talagang to lead the way for this. You have very young people in your department, and I'm sure that if there's anything this administration is known for, you can communicate very well to the public. So let's keep the public interested, and you should really upload the details of the contract in full.
Thank you for that, ma'am. May we wish to inform the Honorable Chairman that the DPWH website now is under the process of improvement to become more customer-friendly. Yes. Thank you, ma'am, for that, ma'am.
Under construction. Okay. So, anybody else would like to add anything before we conclude? Okay. From the OGCC, sir, Mr. Carillo.
Hello, ma'am.
Okay.
Good morning. Like the other resource persons that spoke before me, I wish to echo our office's support to the various bills that would operationalize this constitutional right of our citizens, and also in keeping with the principles of transparency and accountability of officials like us in government. Of significant importance to the OGCC, as statutory council of various units in the GOCC sector, would be the provisions on the privileged communications of in legal proceedings, which under your bill, ma'am, Section 7, Paragraph I, is already specified. Now, with respect to item J of the same section, the OGCC would be very much interested in making sure that the following informations would be included. All the other confidential matters under the arbitration law and the alternative dispute resolution law, including international commercial arbitrations and the arbitration proceedings before the construction industry arbitration. Although stated already in item J that this is already exempt because of provisions of law, the matters that I have disclosed may perhaps be included in the manual that each agency will have to draft in accordance with the measures pending before your committee, ma'am.
Okay.
We
Thank you.
will be submitting, Your Honor, our
Within a week.
within a week.
Okay.
Thank
Pasensya na kasi minamadali rin tayo na
Of course, ma'am.
ipasa ito. Before I conclude, I would like to ask the opinion of Attorney Reyes. Are you the representative of the DFA?
Yes, ma'am.
Because when it comes to diplomatic relations, we have certain exceptions here on divulging information. Are you satisfied with it?
Good morning, everyone. The Department of Foreign Affairs fully supports the proposed bill on freedom of information. and in relation to the discussions made by the Presidential Communications Operations Office, the department submitted its list of exceptions for inclusion in the manual of exceptions being prepared by the Department of Justice and the Office of the Solicitor General. Luckily, the Department of Foreign Affairs limited it to 10 areas only. And if I may mention the areas peculiar to the department, we have requested for the inclusion in the exceptions. First, the assistance to nationals cases and records. This refers to our OFWs, such as death penalty, names of OFWs in detention, drug-related cases, immorality and family cases, and similar cases. Also, we have included ongoing consultations and negotiations, the bilateral and multilateral negotiations, such as the maritime boundary delimitation, the Code of Conduct in the South China Sea, and the International Agreement on Maritime Matters in areas beyond national jurisdiction. Also, we have included our consular records. This refers to our passports and visa matters. And lastly, we have included the records and files of international bodies, I should say, the records of foreign diplomats and consular missions, such as the identities of the members of diplomatic and consular missions and international organizations, the records and data pertaining to arrivals and departures of members of diplomatic and consular missions, the properties owned and rented by diplomatic and consular missions, and all records of vehicles officially owned by the mission and personally owned by the mission personnel. These are guaranteed by the Vienna Convention on Diplomatic Relations and the Vienna Convention on Consular Relations.
Sir, I understand and I appreciate that you were able to spell out those particular provisions, the specific provisions for diplomatic relations. Those will certainly be covered. Under anything that will jeopardize diplomatic relations will not be subject to the Freedom of Information. So you can be rest assured about that. And also when it comes to certain passport informations of private individuals, that again will impede on their right to privacy, so we don't even have to state that exception. There is already a category for that with the right of an individual to privacy. But still, we would like you to submit based on the 16th Congress version of the FOI, to look at your provision that pertains to the Department of Foreign Affairs. And if you think that we need to add a provision or remove something, just submit it to us so we can include it in our discussions before we put together the final bill for presentation in plenary.
Yes, sir.
Okay. Anybody else would like to add anything before we adjourn in record time? It's the fastest hearing I've had. None? Okay, great. How about you?
Madam Chair, before we adjourn, siguro just to again, I didn't get the response from PCO about the investment climate. I hope that we can incorporate this in what we are doing. And just a reflection of what you mentioned a while ago, Madam Chair, with regard to online programs, websites. I think PIA is on top of it, di ba? Parang ino-oversee nila. Sana makita ho natin ito. I would just like to share my experience in TESDA when we launched our e-TESDA program. Before, the government would spend about 1 billion pesos in subsidizing scholarship program for about 100,000 scholars. Right now, if you look at the website of TESDA, there are about 44 courses free online, and there are about 800,000 registered users. 800,000. And halos walang cash out ito sa gobyerno. And I think it's so effective. Kanina binabanggit din ng PCOO na yung impact nito, yung lawak ng mako-cover nito. And that's why it's important also when we post something dun sa mga websites natin, maayos naman at madali i-access, user-friendly naman. So, yun lang po, Madam Chair, and I am hoping and praying na this is the right Congress na magpapasa nitong FOI. Ika-4 na kongreso ko na po ito. 2002 pa ho ako nag-file ng bill on access to information pa noon. And then it's now it became FOI. Kaya I'm really looking forward in ensuring that in this 17th Congress we will see this FOI as a Republic Act, Madam Chair. Thank you.
Thank you, Senator Villanueva. Actually, because of his TESTA program and he led by example, he's one of our most versatile senators. He can actually also be a barista.
I'm a certified, Madam Chair, and I have license to prove it. And to prove that our website works, if you would look at my ID, my license, Madam Chair, and take a photo of this QR reader, you can easily check on the website on what courses I took, and then the competencies that is.
So aside from being a barista, what
well,
else?
you can look for yourself, Madam Chair. Thank you.
I didn't think you want to. Okay. So now, at least you can, your stomachs will not be growling because we're now going to be concluding this. So in this public hearing of the Senate Committee on Public Information and Mass Media on various proposals to enact the Freedom of Information Law, we seek from the representatives of government agencies their comments and proposals on how to improve our bill. So we're giving you, we're requesting that you submit it within a week. As I have mentioned in my opening remarks, we have already unanimously passed the FOI bill in the last Congress in record time. I think that we'll be able to immediately come up with a committee report and sponsor this soon. To summarize the hearing, there has to be a clear segregation of national security matters that could be rightfully disclosed and those that should be kept confidential for being highly sensitive. We heard that an individual's right to privacy is equally important as the right to information. There is a need to balance these two constitutionally protected rights, especially concerning online disclosure of sensitive medical information. Concerns were raised about identity theft that can result from a very broad application of the FOI in relation to personal information provided to the government. An inquiry was raised on how to treat biometrics data in relation to the biometrics registration law. There was a recommendation that administrative offenses under the FOI law should constitute gross neglect of duty. There's a need not to add additional layers to the disclosure process. There were proposals to limit the exemptions under FOI to 10 categories, as suggested by the PCOO. Agencies may need to push for 2 FOI manuals, one for the people and one for government agencies. Emphasis was made on the possible burden that may fall on the frontline receiving officers once FOI is implemented, and there should be proactive disclosure, such as an open data program to complement the FOI law. We look forward to the position papers also to be submitted by the BSP, the SEC, and the DFA, and also all other agencies that would like to submit their position papers. It was recommended that there be a provision as regards to the authentication in relation to the usability of FOI data as evidence in courts, and project-heavy agencies such as the DPWH, are the forefront of preventing corruption through FOI measures. And of course, we commend TESDA for leading the way to user-friendly access of information during the time of the tenure of our TESDA man, Sherwin Gatchalian. I just had to do that before we ended this hearing, Senator Joel Villanueva. So with this, I think it is safe to say that this should be our final public hearing for the Freedom of Information before we submit our recommendation to the plenary. This hearing is happily adjourned. Thank you.